Our second presenter this evening is Tim Duggan. He'll be providing an update on anti-renoviction and anti-demoviction bylaws in Ontario municipalities. And at the end of his presentation, there'll be some time for a Q&A related to his presentation. So please ask your questions then. Tim, we look forward to your presentation, and off to you.
Thank you very much. Good evening, folks. As was introduced, my name is Tim Duggan. I'm a partner with Levitt, Lella, Duggan & Chaplick, LLP. I'm pleased to have been invited to speak to you this evening about anti-renoviction and anti-demoviction bylaws. For those of you who attended this event last year, I presented on anti-renoviction bylaws. Evidently, I did not do a good enough job of boring everyone on that topic last year, as they invited me back for this year, so I'll try and do better with that for this year. So we'll get right into it in order to preserve as much time at the end for questions on the presentation as possible. If we can go to the next slide, please. So, bit of a refresher in terms of what is a quote-unquote renoviction. Aside from being a made-up word that does not appear in any dictionary that I'm aware of, a renoviction is a notice of termination given by a landlord to terminate a tenant's tenancy for substantial renovations that are sufficiently serious that the tenant cannot remain in the unit while the renovations are being carried out. This is governed by Section 50 of the RTA. There are minimum notice requirements, and significantly, there is a compensation requirement and also a right of return. The right of return being that the tenant has the right to come back to the unit after the work is completed at the same rent as was in effect before the tenant vacated. Now, by contrast, if we can go to the next slide, please. A demoviction, also an N13, but different grounds. In this case, this is a termination of the tenancy to demolish the rental unit or to convert the rental unit to a use for purposes other than residential premises. And we're going to be focusing tonight on the first piece, being the demolition piece. One significant difference between a renoviction and a demoviction, and I'm going to refrain from the urge to do scare quotes every time I use either of those words, is that a demoviction does not carry a right of return. If the unit is demolished, the idea is that there's nothing for the tenant to come back to. So there's no right for them to come back. If we can go to the next slide, please. As we discussed last year, some municipalities have either enacted, as we'll explore in more detail, or are exploring anti-renoviction bylaws, primarily because of unfortunately, a tendency by a small group of bad actors to use renoviction powers in bad faith, primarily by refusing to allow tenants to return after the renovations are completed. There's also other behavior that's gone on. There are people who have been misled with respect to their rights. When I say people, in that case, I mean tenants. There have been landlords that have misrepresented the scope of the work to be required in order to induce the tenants to vacate. Again, this is stuff that municipalities are trying to deal with by bylaw. The Landlord and Tenant Board has some powers to address this. They can fine, they can order the tenant to return to possession if the unit is vacant, or if there is no bona fide new tenant in possession, if there's a new tenant in who's essentially a sham or the owner themselves. But what they can't do, if we can go to the next slide, please, is they cannot evict a bona fide arm's length tenant who was themselves entitled to the protections of the RTA. So if the board finds itself in a position where there's an original tenant who'd be entitled to RTA rights and a new tenant who'd be entitled to RTA rights, they can't disturb the new tenant to put the original tenant back in. That's sort of the line that the board and the courts have decided is the limit of the board's jurisdiction. And so this creates the opportunity for a landlord who's acting in bad faith to evict tenants, renovate the units, and re-rent to arm's length tenants at higher rent. We discussed last year, and it remains, as far as I'm concerned, the most notorious case of this as of this year, the 795 College case. And the facts are set out in the bullet points. What I will note is that the total fines there of $135,000 would certainly be higher if that file was heard today, for the simple reason that, as most of you are probably aware, the Landlord and Tenant Board's monetary jurisdiction now is $50,000, instead of the 25 that it was at the time of the 795 College case. And so the board could have ordered 50,000 per unit instead of 25, which is what it ordered there. Now, turning to anti-demoviction bylaws, there's two meanings that a demoviction could carry, and we're going to focus on the practical bad faith one. Strictly speaking, a demoviction could be characterized as any eviction for the purpose of demolishing the unit or reworking it so significantly by way of an internal floor plan change that the unit no longer exists in its original form. The issue that is trying to be addressed here is, well, there are two issues that the municipalities are trying to address here. One is bad faith demovictions. You have a renoviction, you call it a demolition, you try and get the board to agree. And the reason why you do that, as discussed, is because there's no right of return. The other issue that isn't an issue of bad faith, but is an issue of a broader social concern, is with respect to the loss of affordable housing. So even if a project is properly characterized as a demolition, a lot of the projects that are quote unquote best suited to being demolished are older rental stock, which would typically tend to carry lower rents. And so municipalities are concerned about a permanent loss of affordable housing. And as we'll see, a lot of the bylaw changes that have been implemented and are being contemplated is primarily oriented toward this. It's not oriented toward stopping landlords from doing what they're entitled to do under the RTA. And the bottom note there, I have that there's rental replacement bylaws being considered in lieu of a full ban on demovictions. To be clear, a full ban on demovictions would probably be considered to be outside of a municipality's scope, given that the RTA does give the power to demolish and evict. But what the municipalities could do is put into place some speed bumps or some guardrails on the landlord's ability to do this. So some updates since we spoke about this topic last year. At the time that we spoke, the anti-renoviction bylaws were coming, but were not yet in force. We now have some in force. So Hamilton's is in force. Hamilton is the first in kind in the province. As we'll see, most of the other municipalities may be adopting the maxim that there's no need to reinvent the wheel, have chosen not to reinvent the wheel. They're essentially following Hamilton's lead. So Hamilton's anti-renoviction bylaw came into effect January 1, contains numerous provisions. You have to apply for a renovation license within a certain period of time. There's an application fee. You have to obtain required permits. There's a requirement to either provide alternate accommodation or pay the tenant's difference. And there are fines for non-compliance. So the idea there is that any renovation that a landlord wants to undertake has to be legitimate, has to be sufficiently serious to legitimately warrant vacant possession of the unit. And they really want to put some teeth in to prevent landlords from exploiting the power to evict on an N13 for renovation for improper purposes. If we can go to the next slide, please. Other municipalities have adopted or are considering similar bylaws. Toronto's anti-renoviction bylaw came into effect July 31st, 2025. It is substantively similar to the Hamilton bylaw. Given the amount of time for this evening's presentation, I'm not going to go into point-by-point differences. What I will say is that if you're a landlord in any jurisdiction that has an anti-renoviction bylaw, you should carefully review the bylaw and, if appropriate, seek out proper legal advice. I will have cards available for everyone at the end of the presentation if you want. London has an anti-renoviction bylaw, also substantively modeled on the Hamilton bylaw, came into effect in March of this year. Kitchener, we discussed last year. Kitchener had put forward the position, based on advice that it got, presumably, that it didn't have the authority to address renovictions. Sometime between last November and this November, Kitchener apparently had a change of heart in terms of what it could do. They are now working on a draft bylaw that, according to the latest report to City Council, is expected to be ready for City Council's review in Q1 of 2026. Other municipalities are exploring this. Ottawa is in the process of drafting a bylaw, and a report to City Council is expected in the spring of 2026. Mississauga is developing a bylaw Their bylaw is still on the public consultation page. If you want, you can go to the City of Mississauga's website, and there are links there to provide your 2 cents with respect to their proposed anti-renoviction bylaw. Guelph is considering an anti-renoviction bylaw, although that seems to sort of be in the spin cycle of consultation at this point. And St. Catharines, which as of this time last year was thinking about it, is still thinking about it. A couple of municipalities have come out and said or strongly implied that they do not intend to pass anti-renoviction bylaws. 2 notable examples, Brampton and Sudbury. Both of them, there have been publicly reported comments from members of their city council that would suggest, at least as of this time, that they're not planning to do this, although that could obviously change in the future with a change in the political winds or a change in the composition of their city councils. Moving to anti-demoviction bylaws, although these are probably better all characterized as rental replacement bylaws, because they're not anti-demoviction so much as they are limits on demoviction. Toronto's quote-unquote anti-demoviction bylaw, which is really a combination of Section 37 of the Planning Act, Section 111 of the City of Toronto Act, and a matter of general city policy, is generally held up as being the model for rental replacement bylaws. So for those of you who have not gone through a rental redevelopment in the City of Toronto, I hope for your sake that you never have to. It is onerous, it is drawn out, and it is very requirement intensive. The City of Toronto will typically require any rental unit being demolished to be replaced with a comparable rental unit of comparable size with a comparable number of bedrooms at a comparable rent. For tenants that are existing as of the date of the demolition, they are typically afforded a right to return at the same rent, subject to guideline rent increases in the period between termination and reinstatement. For rental units that are not occupied, but that were generally classified as affordable, the landlord is typically required to replace them with new comparable affordable units at affordable rents, and the affordable rents for those units are typically benchmarked to the CMHC benchmarks, whether it's 80% of market, 100% of market, or for mid-range, maybe up to 120% of market. So Toronto is typically, as I said, held up as the model for other cities that are considering their own rental replacement bylaws. Hamilton, as a twin bylaw to its anti-renoviction bylaw, also put into place an anti-demoviction or rental replacement bylaw. Copies a lot of the features from the City of Toronto bylaw, applies to conversion or demolition of residential rental properties containing 6 or more units. The landlord may be required to provide replacement rental units depending on the last rents for the demolished units. So if the demolished units were already above market, then they're not required to replace them with affordable units because you're not taking affordable units out of the rental supply. And as with the City of Toronto requirements, the landlord may be required to provide compensation and notice over and above what's required in the RTA. Kitchener and Mississauga have also put into place anti-demoviction bylaws that are similar to the Toronto and Hamilton bylaws. Now, as we'll see on the next slide, there are a lot of municipalities, Ottawa being a noteworthy example, that appear to have tapped the brakes on potential rental replacement bylaws. And the reason why they have done so is because of the government's enactment of the More Homes Built Faster Act in 2002. This came into effect in, I believe it was December of 2002. And the reason why this is important for this topic is because among the legislation amended by the More Homes Built Faster Act was the Municipal Act. And the Municipal Act was amended to allow the Minister of Municipal Affairs and Housing to make regulations to restrict a municipality's power to pass bylaws to do exactly what we're talking about. This was done under the guise of cutting red tape for housing. But the practical effect of this, and who knows whether this was intended or not, was to prevent a lot of municipalities that were looking at potentially putting in rental replacement bylaws from continuing to pursue it. again, going to Ottawa, there were explicit comments made by City Council at the time in early 2023 to the effect that they didn't see the point in pursuing this bylaw because the minister could just come in and quash it by regulation. Now, the funny thing is that in the almost 3 years since the More Homes Built Faster Act came into effect, it does not appear that the government has actually passed any regulations preventing any municipalities from doing this. So what seems from the outside to be going on is a bit of a game of chicken. You've got the municipalities who want to do it, but don't want to do it. And you've got the government that might stop it, but hasn't stopped it. So we'll see whether the resistible force or the movable object prevails going forward. So that is my roundup of this year's state of affairs with respect to anti-renoviction and anti-demoviction bylaws. And I'm happy to answer any questions that folks might have at this point. Yes, sir.
No disrespect. Does the government not understand that this is a business where a physical structure has a certain timeline to be able to function and it costs too much to carry it? So when they're putting restrictions in that they want to put affordable housing, we get the cost to put roofs on, shingling, whatever, to do repairs. It far exceeds the value of the rent that's actually coming in.
So I can't speak for the government. Doug Ford doesn't return my calls. I don't call him, which is probably why he doesn't return them. But again, speaking from the outside, there's competing stakeholders with different interests, and all of whom are capable of speaking at very high volume in various media outlets to draw attention to their side of the issue. So the issue of landlords being able to essentially cover their investment in a property is certainly an issue that this government in particular, I would say, is going to be sensitive to, given their stakeholders and the folks who support them. This is, I think it's fair to say, relatively landlord-friendly government by Ontario standards. And, we saw some of that, and I don't want to get too far off the presentation, but somebody asked me before I started about Bill 60 and if I could provide my personal guarantee as to when Bill 60 was going to be pushed through. And alas, I cannot. But as you all probably saw, there was some language in there about getting rid of rent control, which attracted the predictable hue and cry and the predictable walkback from the government. But I think it is indicative of where this government's mindset is at in terms of addressing those concerns.
It's just what I'm looking at is a bylaw officer comes to you demanding that you have to keep a certain standard on the building. But in the same way, if not enough revenue is coming in to do the proper repairs, no disrespect, Toronto will become Detroit down the road.
And one certainly hopes that doesn't come to pass. Yeah. In the purple sweater or the purple long sleeve?
Will the net result of this be more slum landlords? There's no incentive for them to remedy the situation. If they can't afford it.
So this is an issue that we see with especially the rental replacement bylaws as it relates to smaller buildings. For a larger scale developer that's putting up a 300 unit building, they can afford to package in 14 affordable units in that 300 unit building. And they make up the nominal loss on margin. But for a landlord that's dealing with a building it's a 14 unit building, if they have to replace all 14 units, you're right, it might significantly affect that landlord's calculus in terms of whether or not to move forward with a redevelopment project.
There's just no incentive.
No.
Yeah. Certainly reduced incentive to do a like for like, to replace the 14 units with a new 14 units.
But then why would you do that? We have to go back for the same rent.
Well, but that's the problem, is if the only people who can take advantage of this are the large scale developers who can put up 300 units, then I agree that would be a practical problem for a small scale landlord. And this stuff doesn't, to be clear, most of this is not geared at most of the folks in this room. It's geared at the larger financialized landlords, because those are the ones who have 10,000 units, and those are the ones who are, accountable to investors and stakeholders and have to return a certain X% per year. And it's not one size fits all. I agree there.
So we are from smaller rental landlords.
Yes.
So if the renovation of the property is due to irresponsibility of the renters, and just for us to be standardized, we are obliged to renovate. So which is due to the irresponsibility of the renters, they would not destroy the property, and we still need to pay them.
Well,
No,
so
you can use fire for that.
Raise the rent, and they still have to bring them back and destroy again the property. What's will happen to us?
So this gentleman anticipated my answer. If the tenant has negligently damaged the unit and it goes beyond reasonable wear and tear and it goes beyond reasonable use, then there may be an avenue for the landlord to terminate the tenant's tenancy on an N5, which gives the tenant the right to void if they want to pay the cost of the repairs or the estimated cost of the repairs. And we as an office have had success with the landlords, not necessarily in this situation where they're looking to turn the unit over, but just generally in terms of recovering the cost, whether it's a private small landlord, whether it's a large landlord, whether it's a not-for-profit. Any landlord is entitled, if the tenant negligently or maliciously damages the unit, to have their claim adjudicated, to have the board award them that amount. And if the tenant doesn't pay, then the tenant has to leave. And in that case, there's no need to bring the tenant back at the same rent because you've already terminated the tenancy on a different basis. You're not terminating at that point on an N13. You're terminating on the board's order on an L2 based on an N5, and they've not voided the N5 within the voiding period if it's the first N5. And then all of this stuff doesn't apply because the unit's vacant.
The only problem there is when we start eliciting them, and LTB is going to take it for months and months. So it's like choosing the worst and the worst, like whichever, right? Because then they will damage more and they will forfeit.
It's
It's this way to appease them. We will renovate. You come back. I pay you also. And so,
again, any such situation is going to be dealt with on its own specific circumstances. And not to do too much self-promotion during this, but I would encourage you to speak to somebody, whether it's my office or somebody else properly qualified to give you advice on your specific circumstances. But you're right, the board's delays, although they are getting better since we sort of hit rock bottom, they are a problem. And the fact that tenants might respond to an N5 by doing further damage to the unit is also a problem. And there are things that you can do. You can do a request to expedite. You can try and get an interim order from the board to try and address the tenant's behavior, but it's a series of imperfect solutions. I agree with you there.
Along as bylaws are newer, have you seen or had experience yet in anyone trying to challenge any of the municipalities' enforcement initiatives on failure to comply with the bylaws, and some strategies may or may not be successful?
So enforcement would probably go through the Ontario Court of Justice in the same way that other breaches of the RTA go through. I've not seen any enforcement proceedings come through yet, and I wouldn't expect to, given the amount of time that stuff takes. Speaking generally, I would expect that any challenge to an enforcement is likely going to turn on the landlord's subjective good faith and lack of intent to breach the bylaw, because it's not criminal, but a regulatory offense is sort of verging into the realm of being quasi-criminal, and it's no longer purely civil. And so making it a strict liability offense, I would argue, if I was arguing it, is not fair to the landlord. So if the landlord can prove good faith and that it's essentially an innocent mistake, I don't know whether that defense would be successful or not. And as I said, I haven't seen anything come through yet in terms of enforcement proceedings.
I guess my question sort of sounds the way
Is sort of seldom seen to meld in a little bit with the RTA process already, and where the four sort of cross. Should I proceed to the LTB, and I may have been successful to receive an order there, my city may say, no, we don't want to proceed because we feel differently. than the LCB or the legislation that you proceed with here. And I'm just curious if there's a crossover or not.
So, and I don't want to get too far into the weeds here, given the forum, but there is a general idea that facts litigated in one forum should not be relitigated in another forum. It's a doctrine called issue estoppel, and it can apply across different scenarios having regard to certain criteria. So if the landlord and tenant board makes certain findings of fact that are directly on point and relevant for a potential city enforcement proceeding, I would argue in the city enforcement proceeding that those facts can't be relitigated. It would be up to the adjudicator there to make that ultimate determination. But there is an existing legal framework, because this probably won't surprise you. This isn't the first situation in which you could have multiple proceedings under multiple headings arising out of the same series of facts. And so there is a robust and well-developed body of case law. The seminal case on this is a case called Cupie in the City of Toronto from the Supreme Court in about 2003. And it's well established what the criteria are for that doctrine of issue estoppel to prevent relitigation of facts to apply. And in fact, a lot of administrative tribunals have developed a practice around what are referred to as Cupie motions for exactly that reason. So if somebody has, for example, criminal charges that deal with certain facts, and those have already been adjudicated, and then the same series of facts lead them to a regulatory issue, like, for example, if a lawyer gets criminally charged and the criminal court makes certain facts, and then the law society gets involved, the law society would probably say the lawyer can't relitigate all that stuff because the criminal court already made a decision. And they would do that on what's called a Cupie motion. So that same sort of process would be available in these circumstances where you've got a tribunal like the LTB that's competent to make those determinations, that has made those determinations on those same set of facts. If it's advantageous to the landlord, then the landlord would say, yeah, the board already found I was acting in good faith. We can't relitigate that. And then it's up to the Ontario Court of Justice or whoever's dealing with the regulatory enforcement to decide whether or not to accept that submission. Not sure how we're doing for time, but probably have time for one or two more? Three more? Okay, I'm being told three more. The red hat, anti-demoviction, the anti-renoviction, I'd have to go back and check. The question was the unit threshold for the bylaw to apply. So it's 6+ for the demoviction. I'd have to go back and check the renoviction to see if there's a unit threshold. Is it any number for the renoviction? Okay, thank you. It's any number for the renoviction. It's 6+ for the demoviction.
Okay, so if we're talking about wasn't the underlying, the person with
Well, in that case, so if it's a conversion to duplex, you'd probably argue that's a demoviction because the unit isn't going to exist in the same form after the work. And in that case, the bylaw wouldn't apply. You'd still have to go through the board's process on the L2, but the bylaw shouldn't apply separately on top of that. Right behind you?
I was gonna ask if
It is a demoviction, and it's was registered with the municipality as a CPM and but be grants. And now it's going to be demolished to a legal duplex. Do you have to get compensation because the ES delegated and said it has to either license for a rooming house and rezoned or license
renovated to a legal duplex.
So there are some carve-outs for the compensation requirement if it's pursuant to a municipal order. It would depend on the specific circumstances. If you're not dealing with a municipal order and it's something that was zoned as a single family, but it's essentially a prior non-conforming use, it's what we used to call grandparented, now legacy use. The compensation requirement would still apply because the board isn't concerned with zoning. It's concerned with whether it's a rental unit. Last question? Yes.
Does this apply if you're ripping out an apartment in your house for your own use?
So if it's a single apartment in your house for your own use and you're deleting the unit, that would be a demolition, and you're dealing with a residential complex that has that is fewer than 6 units. So the bylaw wouldn't apply, but you'd still would have to go through the N13L2 process. But it is a demoviction, but not one that attracts the attention of the bylaw where the bylaw has the 6-unit threshold, and most of the municipalities seem to be keying in on that because they don't want to concern themselves with things like a single basement suite in a detached home. Like that's not their focus. Their focus is on purpose-built apartment buildings, essentially. I'm going to cut the questions there because we're coming to the break. I will stick around for a few minutes if anyone wants to come up and speak to me after, and I apologize for the person who was first in line when the sign went down. But thank you all for having me. I appreciate the opportunity to speak with you this evening, and I'll wish you a good rest of the evening. Thank you.
Thank you so much, Ken. That was a great presentation. So we're on to our third and last presenter of the evening, Elaine Page from Page Paralegal, and she will discuss Bill 10, Protect Ontario Through Safer Streets and Stronger Communities Act, and how Schedule 8 affects you as a landlord. Elaine, we look forward to your presentation, and here's the mic.
Thank you very much for the invitation. My name is Elaine Page, and I am a paralegal who's been doing landlord and tenant files for over 30 years, and hopefully I'll retire one of these days. But but here I am. The invitation was to discuss the Bill 10, so that's what I'm going to be focused on. And really what I want to do is look at this from a very practical perspective, because you guys are all single landlords and often are doing the paperwork yourselves, and so I wanted to address it from that perspective versus the philosophical perspective. So that's how I'm going to focus this discussion. So Bill 10 was known as Protect Ontario Through Safer Streets and Stronger Communities, and it received royal assent on June the 5th, 2025, but it has not yet come into enforcement. So Schedule A, I mean, you have to kind of dig for all of this stuff, but Schedule A refers to it as the Measures Respecting Premises with Illegal Drug Activity Act. So we're talking drugs. This new act gives the police sweeping enforcement ability, where they're not going to need warrants for things anymore. We're not going to talk about the criminality of that because that's not the focus of the discussion. There are various parts to this, but the one that I will be discussing tonight really relates to how this new act holds you the landlords, responsible for illegal drug activity in your rental units. That's both commercial and residential units, but I'm only going to be talking about residential tonight. So yay, another responsibility for landlords. So let's take a look at the regulation, and we're going to start with, and it's highlighted for you. So if you go to the first one, there we go. At 1.2, sorry, can you slide back up a bit, like back to the beginning? I might have missed it. Okay, so we're looking at interpretations and what they are. So if we can go to meaning of landlord, we're going to start there. So the meaning of a landlord, this is in the definition section. It talks about subject to any regulations made under clause 3 sub B, a person is a landlord of a premises for the purposes of the act if the person has leased the premises to a tenant for residential use, the person has leased the premises to a tenant for commercial use, or the person is a tenant to whom the premises is leased whether for residential or commercial use and has sublet the premises to another person. So it's a pretty wide definition. We don't have the specific definition at this stage, but I think that when the regulations are finally written, they will be complementary and in line with the Residential Tenancies Act. So it's not too hard to figure out who the landlord is. If we go to section 2 yeah, there. So this is the part that talks about no person shall knowingly permit a premises of which the person is a landlord to be used in relation to a prescribed offense. And the prescribed offense, again, we don't have the language exactly yet, but it'll deal with trafficking and sale and production of drugs, which would include cannabis. Even though cannabis is legal, you need a license to grow cannabis in your home. I don't know I think you're allowed 8 plants without a license. I'm not sure. But this is all around the purposes of selling the drugs. So if we go to where it says defense, it is a defense to charge under subsection 1 that the defendant took reasonable measures to prevent this activity. So this is where the onus is on you to take reasonable measures to prevent the trafficking of drugs in your units. And I'm going to come back to that in a minute because that's worthy of a much broader discussion about what reasonable means. It's not defined, and there's no case law to assist us, no jurisprudence to assist us as to what the word reasonable means. So it's going to have to play itself out for us to actually know. So what might be reasonable for you is not necessarily reasonable for me, and therein lies the problem. So we're going to unpack that a little bit more in a minute. If we can now go to 6. So this one is great. So it seems on the face of it. This is some of the enforcement powers that the police would have, and that's removing persons from the premises. And it says, if a police officer has reasonable grounds to believe that a prescribed offense is being committed on any premises, the police officer may require that one or more persons vacate the premises. So wouldn't that be nice? We've got drugs happening in the unit and the police show up, they make their bust, that's it, the tenancy's over, and we got rid of that bad tenant. Wouldn't that be awesome? Yeah, it really would be, but unfortunately, that's not the case here. Don't get excited because if just below there, subsection 3 says subsection 1 does not apply in respect of a person residing in the premises. So what? Remember, this is an act that deals with both commercial and residential tenancies. So the removing of somebody from a property is really only commercial. It's not residential.
Mostly always residential.
Sorry, most of the drugs are well. So some this gentleman saying most of the drugs are residential. I don't know. I'm not that involved in the trafficking of drugs, but certainly there are commercial venues that are fronts for major drug operations, and I think that's part of the reason that they've created this in the way that they have is to rid themselves. I'm just anecdotally, I remember many years ago, the Molson's factory in Barrie got sold, and for years they were growing pot out of there and until they got busted. So that's the kind of operation we're talking about. So if we can go to offenses, it'll be the next highlight, right? So, yes, I am talking to you in legalese, but I'm going to break it down. So, offenses. A person who contravenes blah, blah, blah is guilty of an offense. Same directors and officers of a corporation. So, what that means is that corporate protection that you have is out the window. So, there are a number of people who will have rental units, and for whatever reason, tax reasons and various other reasons, they'll put the unit in a corporate entity and believe that they have protection as individuals under that corporate entity. For the purposes of this act, no, you don't. If you're the person, the officer and director who's running the show, and you knowingly allow um, drug activity in your unit, then your corporate shield isn't going to help you. So the offenses, if we move slightly to where it says penalties, they're pretty scary. So an individual who's convicted of contravening the act on first conviction in respect to that subsection is a fine of at least $10,000 and not more than $250,000, or to imprisonment for a term not more than 2 years, less a day, or both. So that's pretty substantial. And I don't see the average person having to worry about it that much. It's really for people who are renting out the space with the intention of creating these grow ops. So those are the people who are going to be getting a more serious fine. And if it's a corporation, it's 25,000 and no more than $1 million. So it's huge, these fines. So the other piece of this is there's a prohibition that says no person shall knowingly possess the proceeds of an offense under this act. And so what does that mean? It means potentially that if you've got a grow up going on in your rental unit and your tenant seemingly has no other source of revenue and you're taking rent, you are potentially receiving the proceeds of the illegal activity, and you could have a problem. So have I scared you enough yet? Because it's pretty scary stuff, right? I fully acknowledge that.
You're not facing this if you're fighting.
So hang on. So now we're going to jump back to what you can do to protect yourself. And I want to come back to a discussion about what is reasonable. So remember, you have to take reasonable actions in order to defend yourself. So we're good. We don't need this anymore. Thank you. So I have dealt with over the years many situations where there's been drug dealing going on. And just recently, one of my buildings on Broadview, the landlord, it says a 200-unit building, the landlord called and said, we know that there's drug trafficking going on in a particular unit. And so I said, call the police and report it. And I don't know if anybody else has had this experience, but the police are like, yeah, thanks for letting us know. That's great. Okay. Well, are you going to do anything about it? We'll get back to you. You should maybe put it on tips, and then, they'll look at it through the tip line. And that was it. No response. And that's really a big problem now that this act is coming into place, because you've got nothing to show as a landlord that you've taken any reasonable steps. So it's probably true that the police aren't going to do much. They're not particularly concerned about an individual who's trafficking out of a unit where it's kind of minor. There's maybe 4 or 5 people a day coming. They don't have the manpower, they don't have the financial resources to answer and investigate all those calls, and often they don't. When it becomes more serious, then sometimes they do. So you got to protect yourself. It's as simple as that, and this is reasonable. So if you're going to go to the police station and report drug use in your unit, make sure that you take the name and the badge number of the police officer that you made that report to and diarize it, because that becomes evidence for you down the line should you require it. If you make a phone call to the police to make that report, record the call. Everyone has a cell phone, and you hit the button and it can record your conversation. You are allowed to record a conversation that you're involved with on your phone. You want that as a record. if the tips, I was looking this up for City of Toronto. There are some jurisdictions that will allow you to do an online report. The City of Toronto doesn't do it for drugs. It's things like illegal parking and graffiti and hate crimes and that sort of thing, but it doesn't have on their online portal something for drugs. So, which is why they tell you to do it through tips. So screenshot because you don't always get something back. You might just get an email back saying, we've received your report, but no, there's no report attached and you don't get a copy of it. So make sure to screenshot any reporting that you do. Again, make sure that the date and the timestamps are on those screenshots, because that's your defense. If suddenly your building gets raided and they want to make a big deal and they want to charge you, you've now got a defense available to you. You've got phone calls and screenshots and badge numbers and all sort that. And so to me, that's reasonable. That would be a reasonable attempt. And I would suggest to you that you should make more than one attempt, because the reality is the police aren't likely going to come out. And again, I'm guessing here based on sort of a common sense, because we don't have the regulations yet. But the idea is 3 attempts over a short window of time is probably the way to go. And then you've got validation. So the other way, of course, is to go to the Landlord and Tenant Board, which has its own problems around these sorts of files. And so there are 3 different notices that you can do, and we're going to take a look at all 3 of them, and I'm going to give you some direction. Again, more so because I think some of you are filling out forms yourself, and I want to make sure that you're doing them correctly. So under Section 61(2) of the RTA, there are 3 specific drug offenses, and these are grounds for eviction through the board. 1 is production of an illegal drug, 2, trafficking of an illegal drug, and 3, possession of an illegal drug for trafficking purposes. So the first notice that people often will go to is the N7. So if we can just take a look at the N7. I'm sure many of you are familiar with these documents. Okay, so we've got, this is what's known as an N7. And it's a notice to end your tenancy for causing serious problems in the rental unit or the residential complex. This is, if we slide down, it'll say, I'm giving you this notice, and the reasons are: 1, your behavior or the behavior of someone visiting or living with you has seriously impaired the safety of another person, and this behavior occurred on the residential complex. 2, you or someone visiting or living with you has willfully damaged the rental unit or the residential complex. Or 3, you or someone visiting has used the rental unit or the residential complex in a way that's inconsistent with its use as residential premises, and this has caused or can be expected to cause serious damage. And we're not going to worry about 4 at the moment. So a lot of people use this notice or try to use this notice for drugs. And I can understand why you would, because often when you have a drug problem in a building, you've got people holding open doors and people in the hallways passed out, people on elevators stoned out of their minds, accosting other tenants. So it's often this notice that people go to, but this notice is, I would argue, not the right notice to be using. The bar and the test on an N7 is so high that it is almost impossible to get an eviction on an N7. I will tell you that during COVID, I had a case where they were actually dealing in guns. I mean, in the unit, there was a cache of weapons in the unit, and people were coming in and purchasing weapons. And partially because it was COVID, but the board didn't think it was, serious enough to warrant an eviction. And a lot of times with these N7s, you actually want to have somebody charged. And as Tim was saying, once there's a charge, you can't, the evidence doesn't change from one venue to another. If there's a high suspicion and there's actually a charge, then you might consider this. But this is not my go-to, and I wouldn't recommend doing it. I also wouldn't recommend, a lot of times what people will do is they'll double up on notices. They'll do an N5, an N6, and an N7, all of which will have different termination dates. And then the tenant says, I'm confused because I have 3 different termination dates, and it's all relating to the same incident, and the board may throw it out. So don't do that either. Okay, let's take a look at the N6, please. So this is the one that's really set up for drugs, and yet it's not always the best one to use. So why? I'll tell you why in a minute. So in N6, the reasons, under reason 1, I believe you or someone living with you has committed an illegal act or is carrying on an illegal business at the residential complex involving the production of an illegal drug, trafficking in an illegal drug, possession of an illegal drug for the purposes of trafficking. So it seems on the face of it that this would be the right unit, the right notice to use. But where this becomes problematic is you don't always have the right evidence. I mean, there's a common knowledge it's like more likely than not that drug trafficking is happening. But unless you go and you buy drugs from the tenant, you really don't have much proof. You can highly suspect it. I mean, the other time is when we do have the police come and do a raid and make an arrest. Then, of course, you've got evidence to support the application. But the bar on this is also really, really high. And there is a decision, Ball versus Metro Capital, which is a sort of a famous decision that talks about the details and particulars in the tenant needing to know what the application is about in a fulsome way. And often with the N6s, the tests on Ball versus Metro Capital are not met. So you could use this, but you have to be really sure. And I'll tell you, I recently used it where we had video in the hallways. We had a bad drug problem in Thunder Bay, which has a huge problem with fentanyl. And we had somebody dealing in fentanyl in the building. And so we installed security cameras, and we were able to see people walking in and out like every 5 minutes, banging on the doors. We had video of it. We had video of a transaction happening at the door. We had video of somebody exiting the unit and in the hallway cooking up whatever it was they were cooking up and ingesting it and then passing out. So that's really great evidence, but you don't get that kind of evidence often. So I mean, again, I'm talking about this from a reality perspective. What the act says and what these notices say and what the board says and does is not necessarily the same thing. So I'm coming from this perspective of having done these files and witnessing these files for a long time. So the next one that we have would be the N5, and a lot of you are familiar with N5. And the N5 is distinguishable between the other 2 notices for a couple of reasons. The first is that the other notices are what we call non-voidable notices. You did this, and you have no more chances. That's it. You're done. An N5 is avoidable notice, which means it gives the tenant an opportunity to correct behavior. And this is where Ball versus Metro Capital really comes into play, because a lot of you guys are doing your notices and you forget to put in this little sentence about how one can correct their behavior. And without that sentence, your applications will fail. So typically, we see noise complaints and we have a long list of blaring stereos between this day on this hour, between this on this day between this hour and this hour, the stereo was blaring, and the whole long list of them, which is what you need to do under that case law. But nowhere does it say, there might be 20 incidents, and nowhere does it say the tenant must stop blaring music late at night or after hours and stop generally causing noise that is disruptive to other tenants. And because that's not in there, application fails. So if you're going to use an N5 for drugs, you need to actually make sure that you have a sentence in there as to how the tenant can void the behavior. So I wouldn't necessarily on an N5 say that somebody is dealing in drugs, because you may not have the evidence to support that. But the behavior around drug dealing is what's disruptive. So usually if you're in a building, somebody is altered the main door or a side door, they've leave it open so people have access to the unit. So the act of leaving that door open is substantially interfering with the rights of the other tenants, because it becomes a safety issue. The security doors are not secure. You often get people coming in who don't know the unit that they're supposed to go to buy their drugs. So they'll start banging on doors. They're often doing it in the middle of the night, screaming for George, open the door, George, right? And that's substantially interfering with the reasonable enjoyment of everybody else. So that kind of behavior, the ongoing traffic, I've seen scenarios where people have literally been lined up in the hallway to do their transactions, and they're having a party in the hallway. Those are the kinds of things you can put on an N5 without, on the balance of probabilities, drug dealing is happening, but it's the behaviors that are associated with the drug dealing that are problematic. And again, you're doing an N5, there is a distinction between the first N5 and a second N5. So when you do an N5, the tenant has 7 days to void. So in that 7-day period, if they don't do anything, if they're fine, like they behave themselves, and on the 8th day they start up again, then you can actually serve the second N5, which is not voidable, and issue your application. So you have 6 months to do that. What often I see is people filling out N5s for a noise complaint or something of that nature, and then something else happens and they serve a second N5. But it's not the same thing that was on the first N5. So that's not okay. That's it. For each issue, you have to do your own N5s. So I think we're done with this. Thank you. The reality is, we never know what's going to happen at the board. If you have this situation, as you all know, the board's gotten much better in terms of timelines, but they're still taking too long for certain types of applications. L2 applications still take about 5 months to get to a hearing. And that's a problem if you've got a drug situation in your unit. So there is the ability to file for an expedited hearing, and I would encourage you to do it. You may or may not get the hearing, but again, coming back to full circle about protecting yourself. So now you have all of the other evidence, plus you've got an application at the board, plus you've asked for an expedited hearing. That would tell any trier of fact that you have taken this issue seriously and that you have taken all reasonable steps to ensure that the situation is dealt with at the board. You're in the hands of the board. You have no control about when you're going to get heard. You have no control about whether on the day of the hearing you're actually going to get heard. And you have no control of when the order comes out, and you have no control of when the sheriff comes. But you have taken all of the steps you have needed to prevent yourself from getting $1 million fine. And that's really important. So that's kind of where I'm at with this, but I'm happy to answer any questions.
Fortunately, I've gone through this, and I used the M5, but what I did do is I had every time the tenants were complaining or something that was going on, I had them call the police. I had the text messages, and then what happened was I spelled out on the first M5, the police have been here this day, this day, this day, this day. Behavior has to stop. And then the second one, again, the same thing. So then when I'm going to court, I provide as evidence all the police reports.
Right. So the suggestion here was to have the other tenants phone the police. Let's separate the issue. There's how you deal with the board and how you deal with this new act that's coming into power. So from the perspective of the new information, having your tenants call the police, in my view, is not meeting your obligation.
I was doing it also.
I understand, but I just want to make the distinction. I'm trying to protect you from getting fined. I'm not here so much to talk to you about how to evict a tenant that is, dealing in drugs. This is about this new act. Yes, sir.
I have two questions. One is, would you do it in parallel, like this board and call the police and record the conversation and the tips all at the same time?
Yep. So that's a great, you want to have several attempts. You want to be able to prove that you have made several attempts, that you haven't ignored the problem, and you've made several attempts in different ways to try to resolve the problem.
And what would you suspect the very poor version that the child of a tenant might be taking drugs on you? Is that a plan?
So there's a distinction between somebody taking drugs, and they may, some human rights stuff comes into play with that because there may be an addiction issue. There's a big difference between some guy who's smoking a joint and trafficking. So if it's an individual who may have a drug problem, and if they're contained in their own unit and not disturbing anyone else, then this would not apply. In the back, yes.
So are you suggesting that you have
a center with noise issues, with overcrowded, with harassing other centers? You should be issuing his.
No, you can issue an N5 for the 3 different issues, and in fact, I would recommend that. I'm suggesting that if yesterday it was a noise issue and you issued an N5 on that, and today it's a different issue, that first N5 isn't going to apply to this new issue. So collectively, it's good to actually get as much on there as you can.
So then has the second issue has to be the exact same offense?
Sort of. Okay, so we have an N5 and there's 3 issues on the N5. That if there's a breach, and it has to be a breach of one of those 3 issues, then you can proceed. If it's something entirely different, then it's a new first N5. Okay. Yes.
Oh, it's just a question. Regarding, you had property manager, and then where's the liability? Oh, I see. The landlord's innocent. You have no idea.
Yeah, that's a great question. Thank you for that question. So the question is if it's a property manager who's just, looking after the building and the landlord's not really involved in the day-to-day operations, who's liable? So this falls under who would be the landlord, and we don't have the definition yet. So I can't really answer, but if you look at the definition under the RTA, there have been many cases where the property manager has been the sole contact person and does all the day-to-day business of the landlord, that they have been held liable for other types of offenses.
Sorry, just to recap. So the N5 notice, the issue has to be consistent.
If you want to proceed on it, yeah.
If your first offense was making a lot of noise at 1 o'clock in the morning, and the second, so after 7 days, that problem got resolved, then he starts threatening another tenant.
That-
Is that a total?
It's a totally different N5.
First N5 is
The first N5 is about noise, and now this particular tenant is threatening other people. That's a separate issue. It would be a new first N5 on that issue.
So a professional tenant could come up with different issues every time to avoid the.
Yeah. Okay. So what I do as a practice, usually if a tenant is misbehaving, it's not just a singular misbehave. So typically, I'll get somebody who I just had this yesterday. It's a house with 2 apartments. The basement apartment just had a baby. The baby's crying. Upstairs is upset because they can hear the baby crying. So they're banging and they're cranking their stereo. So that's one issue of noise. And they're also retaliating by blocking their car in. And so that's a second issue. So if I put all of that on one N5, then if they block the car again, I could proceed. If I only put the noise on, then I could not proceed on the blocking of the car.
So one N5 could have multiple.
Yes. So again, with Ball versus MetroCap, it's really critical on your N5s to have dates and times and details about events. You can't just say the tenant's causing noise and disturbing other people. You have to actually. So what I recommend, and this again, because I'm not here to really talk about N5s, I want to just recommend to you that you start taking logs, or you ask the tenants to create a log when these things are happening so that you can then plug all of that information into the N5 and you'll meet the challenges that the case law brings. And yes, last question.
Any law there to protect us as
Sorry. You're so funny. She asked if there's any laws to protect the landlords. Like, are you new?
The thing is, these drugs and cannabis, it's really a serious case.
Yes.
So what happens is if we report and it will take months and months for the LTD to address, they can just say, no, nothing is selling here. But we can be on the red flag someday.
So the idea is, yes, you're right. I mean, the idea that, and the message that I'm really trying to get out to you guys is, we can't control what the LTB does. We can only control what we do. And I want you to be protected from getting these fines because you have, unfortunately, a bad tenant. The only other thing I want to say, and I missed this, there are steps that you should be taking at the beginning of your tenancies, which are the standard things that you hear over and over again. Go on Open Room and all of those, and do Google searches and really check your tenants out before you rent to them. Have agreements, have clauses in your lease agreements that talk about illegal activity. Yeah, and like in the schedules to ensure that. It's really comes down to tenant screening. That's probably the most important thing that you can do. So,
So can I ask you, Bill 10, going back to the Dorgish, right?
yep.
Bill 10. So the fines will come from who? Who will fine?
It's a really good question because I was trying to figure that out myself. I mean, the court.
Because why I'm asking the question is, unfortunately, I've had this experience. But then, I agree with what you're saying in reference to tenants, but in the same way too, um, if you're the landlord, you call the police want you there and you witness the situation yourself. If you have, so what happens is that they know that I'm coming, choo, the cockroaches are gone. So then I ended up, when I went to court, I had called and I applied for getting my case there, but I had 3 different tenants that also I provided as evidence. Their times they call, also because they're there to prove to the police, yeah, look at the guy, he's laying there plastering out of the skulls, and then they're calling the ambulance and the police notes. Like what I'm asking is, Bill 10 originally, is it the courts that are going to find her?
So the question is who's going to do the fines? The legislation hasn't been drafted yet. And it's part of this is what I've shown you. You'll notice it was all in gray. So when something's in gray on e-laws, it means it hasn't come into effect yet. So there's still some work to be done around how these charges will be laid and who will lay them and who has jurisdiction to hear them. We don't have that information yet, but I would expect it would be coming out very soon.
So it's not a lot.
It's not law yet. Thank you.
Thank you very much, Elaine. Appreciate that. Great presentations.
So,